Hello, foodies. How y'all doing? There's been an update to Ernest Paul Dog Williams case. The motion that was filed, called a general demurrer and special demurrer, it was denied. Big Hoove was denied. He wanted, Nesto and Big Hoove wanted count 1, the Georgia RICO charge, dismissed. So think of it like this. The general demurrer was, even if everything in this indictment is true, it still doesn't describe a crime. The special demurrer was stating that the indictment is too vague and we don't know exactly what he's being accused of. Okay, so isn't that kind of like, I don't know. I don't know how they relate or how they correlate, coincide, or whatever. I guess it's a routine to do that together. I don't know. But anyway, Judge Dunaway said no. This is why. The judge said the indictment is legally sufficient because it lists the elements required under Georgia's RICO statute. It explains that Williams allegedly obtained money and property through a pattern of racketeering activity, and it identifies the types of property involved. The court concluded that if the allegations are proven, they describe a violation of Georgia's RICO law. In other words, this indictment does state a crime, and the case can proceed. So this is why he lost the special demurrer. This is an important point. Georgia law generally requires a special demurrers to be filed within 10 days after arraignment unless the court extends the deadline. Judge Dunaway found that Williams filed his demurrer too late. Dang. So he waived that challenge. But the judge went even further. He said, even if the filing had been timely, I still would have denied it. That's because the indictment, when read together with the alleged racketeering acts, gives Williams enough information to understand the accusations and prepare his defense. The judge's bottom line, the final conclusion is very straightforward. Judge Dunaway ruled that count 1 is capable of supporting a conviction if proven. Williams has been adequately informed of the accusations. I don't know why I had some chips and salsa right before this. I'm wondering if that's why I'm stumbling and fumbling. And Judge Dunaway also ruled that both the general demurrer and special demurrer are denied. I'm going to read the document to y'all. So, but before I read it, and I'm also going to put it in members only. What this means for Nesto, this order does not mean he's guilty. It simply means 1, the RICO charge remains, 2, the indictment stays in place, and 3, the prosecution can continue toward trial. The defense does not get count 1 dismissed at this stage. The prosecution doesn't have to prove guilt in this motion. They only had to show that the indictment is legally sufficient. The biggest takeaway, one sentence that stands out, is count 1 is capable of supporting a conviction. That doesn't predict the trial's outcome, but it tells us the judge believes the indictment is legally sound and can go before a jury. All right, so the document reads as order denying demurrer. In a 39-count indictment returned on April 23rd, 2024, defendant is charged with violation of the Georgia RICO Act, false swearing, theft, identity fraud, false documents, and other related charges arising from acts beginning in December 2009 and continuing through June 2022. On July 22nd, 2024, defendant filed a general demurrer to count 1 RICO. Y'all. This man filed this July 2024. However, in the written filing, defendant argues that count 1 of the indictment fails to allege an offense and is subject to both general and special demurrers. For the following reasons, defendant's general and special demurrers are hereby denied. General demurrer. Turning first to defendant's general demurrer, defendant moves to dismiss count 1 of the indictment for failure to state an offense. asserting that the indictment fails to allege the essential elements of the offense with sufficient factual particularity. For the following reasons, the court disagrees. An indictment shall be deemed sufficiently technical and correct to withstand a general demurrer if it states the offense in the terms and language of the code or so plainly that the nature of the offense charged may easily be understood by jury. Smith versus State, 340 GA App 457, blah, blah, blah. To withstand, so this is cited in the case. To withstand a general demurrer, an indictment must 1. Recite the language of the statute that sets out all the elements of the offense charged, or 2. Allege the facts necessary to establish a violation of a criminal statute. The true test of the sufficiency of an indictment to withstand a general demurrer is if all the facts which the indictment charges can be admitted and still the accused be innocent, the indictment is bad. But if taking the facts alleged as premises, the guilt of the accused follows as a legal conclusion, the indictment is good. All right, defendant in this case is charged with violation of Georgia's RICO Act, which states that it shall be unlawful for any person through a pattern of racketeering activity or proceeds derived therefrom to acquire or maintain directly or indirectly any interest in or control of any enterprise, real property, or personal property of any nature, including money. Here, the indictment alleges that defendant individually and as a person concerned in the commission of a crime acquired and maintained directly or indirectly an interest in and control of real property and personal property, including but not limited to United States currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and a residence. A residence? A residence? Oh, y'all, through a pattern of racketeering activity as described below. Lord have mercy. I'm like, Lord, who house he took, y'all? Who house did he take? Okay, the court finds that this language is consistent with OCGA 16-14-4A and alleges the facts necessary to establish a violation of the statute. Further, the court finds that taking the facts alleged in the indictment as premises, the guilt of defendant or violation of the statute follows as a legal conclusion. Accordingly, defendant's general demurrer is hereby denied. All right, special demurrer. To the extent defendant asserts a special demurrer, Georgia law provides that A, 11 pretrial motion, states that all pretrial motions, including demurrers and special pleas, shall be filed within 10 days after the date of arraignment, unless the time for filing is extended by court. The failure to file a timely special demurrer seeking additional information constitutes a waiver of the right to be tried on a perfect indictment. State versus Wilson. Citation omitted. As noted above, defendant did not file this demurrer in this case until July 22nd, 2024, and accordingly waived his right to be tried on a perfect indictment. Gotta be quicker than that. Big Hoove, gotta be quicker than that. Had defendant not waived his right to be tried on a perfect indictment, the court finds that his special demurrer would still fail. A general demurrer challenges the sufficiency of the substance of the indictment, whereas a special demurrer challenges the sufficiency of the form of the indictment. Smith versus State. And citations were omitted for that case. A true test of the sufficiency of an indictment to withstand a special demurrer is not whether it could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet, and in case any other proceedings are taken against him for a similar offense, whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. It is useful to remember that the purpose of the indictment is to allow a defendant to prepare his defense intelligently and to protect him from double jeopardy. Stapleton versus State. Here, count one and the acts of racketeering activity set forth in the indictment, when read together, sufficiently apprise defendant of what he must be prepared to meet with respect to the charge, and show with accuracy to what extent he may plead a former acquittal or conviction. As a result, the indictment allows defendant to prepare his defense intelligently. Accordingly, defendant's special demurrer is hereby denied. In sum, after careful review of the indictment and considering all arguments made by parties, the court finds that count one is capable of supporting a conviction, and therefore defendant has been properly informed of the nature and cause of the accusation against him. For these reasons, defendant's general and special demurrers are hereby denied. So ordered this 23rd day of July 2026. Honorable Eric K. Now, why that took 2 years, I don't know. But maybe, just maybe, that gives us an idea that something might happen August 10th, y'all. That's Nesto's next date, next hearing, August 10th. So basically it's saying Nesto knows full and god darn well what he's being charged for and why. And you filed stuff too late and you waived the right to something else, so get out of here with that mess. Denied. So what do y'all think about the motions being denied? The general demurrer and the special demurrer. What y'all think Nesto saying? Does Nesto know yet? 1:27 p.m. is when this was e-filed. So does Nesto know? Has he got the word from the turd, Sean Hoover? All right, well, thanks for watching. Like, comment, share, and subscribe, and hit the notification button so you don't miss any of my videos. Talk to y'all later. Bye.